Hi guys, good evening. So for today, instead of preparing a presentation on a particular concept in taxation, I opt to prepare a presentation, some sort of presentation pa rin naman, but this case, it is an actual case that has been decided and unbanked resolution of the Supreme Court. Okay? So, for those of you who are would love stories, so ito yung mga one of the stories that na merong kapupulutan talaga na aral, as in literally. So now we have here the case of Film Development Council of the Philippines versus Colon Heritage Realty Corporation. So that's FDCP versus HRC here. With the General Register number 203754, and the other one is the case of FDCP versus City of Cebu and SM Prime Holdings Incorporated. So this was decided last October 15, 2019. So less than a year pa lang, no? So very recent na case. Okay, so let's go to the facts of the case. This is for resolution, by the way. You have here Film Development Council of the Philippines who filed a motion for reconsideration. Colon Heritage filed motion for partial reconsideration. And City of Cebu filed a motion for partial reconsideration. So these are for resolution. So the facts of the case are as follows. You have here sometime in 1993, Respondent Cebu City passed City Ordinance number 69, otherwise known as the Revised Omnibus Tax Ordinance of the City of Cebu. So, ano bang sabi ng Ordinance number 69? So, sabi, in its sections 42 and 43, Chapter 11 of the Ordinance, required proprietors, lessees, or operators of theaters, cinemas, concert halls, circuses, mga amusement places, amusement, oo nga, cinema, concert, yan, saan nga, other places of amusement, to pay an amusement tax, magbabayad daw yung mga lugar na, those identified, ng amusement tax equivalent to 30% of the gross receipts of the admission fees to the office of the City Treasurer of Cebu City. Ngayon, on June 7, 2002, Congress passed RA 9167 creating Petitioner FDCP. So, ano naman din yung nakalagay sa RA 9167? So, Sections 13 and 14 thereof provide that amusement tax on certain graded films which would otherwise accrue to the cities and municipalities in Metro Manila and highly urbanized and independent component cities in the Philippines during the period the graded film is exhibited, sabi, should be deducted and withheld by the proprietors, operators, or lessees of theaters or cinemas and remitted to the FDCP, which shall reward the same to the producers of the graded films. So, noong 1993, sabi ni Cebu City, magbayad kayo ng amusement tax sa amin, sa Office of the Treasurer of Cebu City. Right? Now, on June 7, 2002, sabi naman ni FDCP, hindi, sabi ng batas, sa amin kayo magbabayad, okay, ng amusement tax. Now, according to FDCP, since the effectivity of RA 9167, all cities and municipalities in Metro Manila, as well as highly urbanized and independent component cities, have complied with the mandate of RA 9167 with the sole exception of Cebu City. Wow, diba? Cebu City lang talaga yung hindi nag-comply, guys, sabi ni FDCP, which adamantly insisted on its entitlement to the amusement taxes and hence prompted cinema proprietors and operators within the city to remit the same to it. Okay. Consequently, so anong ginawa ni FDCP? Nagpadala ng demand letters for unpaid amusement tax with surcharge sa mga proprietors and operators, including na dito si CHRC, si Colon Heritage, at saka si SM Prime Holdings. Okay? So, as a result of the demand letters, Cebu City filed a petition for declaratory relief. So, nag-file sila sa RTC of Cebu City. Branch 14. Branch 5. Sorry. In September 25, 2012, nag-file sila ng case, hindi itong filing case now. So, ito pala yung date ng decision. On September 25, 2012, RTC of Cebu City Branch 5 issued a judgment in civil case which declared sections 13 and 14 of RA 9167 as invalid and unconstitutional. Okay. So, noon naman, consequently, noong October 24, 2012, RTC of Cebu City Branch 14, similar decision, ruling against the constitutionality of sections 13 and 14. So, ito yung mga sagot sa final na case ni, final na mga petition for declaratory relief ni Cebu City at saka yung isa, sino yung nag-file? Si Colon Heritage. Okay? So, si Cebu City sa branch 14 siya. Tapos, si CHRC nag-file naman ng same petition sa branch 5. For both of the petition, nagsabi si RTC Cebu na yung section 13 nga at saka section 14 is invalid and unconstitutional. Okay, anong nangyari pagkatapos? So, aggrieved, si FDCP filed 2 separate petitions for review and certiorari before the court presenting the singular issue as to whether or not nagkamali ba ng decision si RTC of Cebu City when it declared that section 13 and 14 as unconstitutional. So, the petitions were later consolidated in the court's resolution dated March 4, 2013. Now, anong nangyari? So, sabi dito, on June 16, 2015, the court rendered the main decision in this case affirming. So, in-affirm nila, no? O, affirming the assailed RTC decision. Ano yung decision ng RTC? Unconstitutional daw. Invalid and unconstitutional. So, it ruled, ano ba yung reasoning niya? So, it ruled that these provisions violated the principle of local fiscal autonomy because they authorized FDCP to earmark and hence effectively confiscate the amusement taxes which should have otherwise inured to the benefit of the local government units. Okay? In this relation, the court further found that the grant of amusement tax reward does not partake the nature of a tax exemption since the burden and incidence of the tax still fall on the cinema proprietors. However, as a matter of equity and fair play, the court applied the doctrine of operative fact and rendered, among others, the following dispositions which are subject of the present motion. So, may tatlong disposition. We have 3 forced dispositions. So, meron din tatlong motion for reconsideration. Yung dalawa, motion for partial reconsideration. Yung isa, motion for reconsideration. So, disposition number 1, sabi ng court, FDCP and the producers of graded films need not return the amounts already received from LGUs because they merely complied with the provisions of RA 9167 which were in effect at that time. So, sabi naman ni Cebu City in its motion, it argues in its motion against the application of the operative fact doctrine which is the basis ng decision ng court. So, sabi naman sa disposition number 2, we will discuss operative fact doctrine maya-maya pala. So, in disposition number 2, any amounts retained by cinema proprietors and operators due to FDCP at that time would be remitted to the latter since section 13 and 14 of RA produced legal effects prior to their being declared unconstitutional. So, sabi, lahat ng mga nasa kamay, di ba, ng mga proprietors and operators, kinakailangang i-remit nga kasi legal din naman yung section 13 and 14 before they were being declared unconstitutional. Now, sabi naman ni CHRC sa motion niya, it did not withhold the remittance of amusement taxes on graded films to FDCP, di ba? Kasi nga, nagbabayad din kasi daw si CHRC, hindi nga lang sa FDCP, pero sa Cebu City, di ba? It claims that notwithstanding the effectivity of sections 13 and 14 of RA 9167, at that time, it had already paid and remitted all due taxes to the right authority. At that time, of course, in their understanding, that is Cebu City. Hence, it should not remit any more taxes. So, bakit ba ako magbabayad kay FDCP na nagbayad naman ako kay Cebu City, di ba? So, doing so would amount to double taxation. In this regard, CHRC, Heritage prays that it be declared relieved from any obligation. So, sa prayer naman nila, huwag na kaming pabayaran kasi nagbayad naman kami sa Cebu City eh. So, in the alternative, sabi ni CHRC, they would want to manifest that it is willing to go through a factual determination before the trial court to prove, okay, that they would prove that it had indeed fully paid and fully remitted said taxes to Cebu. So, yun na lang yung gagawin namin, court. Yan na lang yung gagawin namin. We will prove na nakapagbayad kami ng amusement tax. And lastly, on the last disposition, the third disposition for resolution, cinemas, proprietors, and operators within should not be held liable for any surcharge since they did not know. Wala silang alam kung whether or not it was proper for them to remit the amusement taxes to either FDCP or Cebu City at the time. Oo nga naman, kung ikaw naman din yung mababayad ng buwis, sino ba yung most probably babayad mo? Yung malapit, di ba? So, si City of Cebu yung binayaran mo. Hindi mo din naman alam kung sino sa kanilang dalawa. So, si FDCP nag-motion din. Seeks the imposition of surcharges to the delinquent taxpayers who failed to remit the proper taxes at the time Sections 13 and 14 of RA 9167 were not yet declared unconstitutional. So, ginamit din yung operative fact doctrine. Nung panahon na yon, it's still valid and constitutional unless dineclare nga ng court na invalid and unconstitutional. So, dapat kayong magbayad sa amin. O, diba? Yun. So, now, how about the court's ruling? Punta tayo sa court's ruling. At the center of all three motions, yung sa tatlong ito, guys, it's centered to the proper application of the doctrine of operative fact. Or ito. So, yan daw. It's centered. Ano nga ba yung doctrine of operative fact? So, dito sa baba, nilagay ko na lang. It is a well-settled rule that an unconstitutional act is not a law. Okay? It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is inoperative as if it has not been passed at all. Yun daw. So, applying this principle, the logical conclusion would be to order the return of all the amounts remitted to FDCP, diba? And given to the producers of graded films. So, yung lahat na nagbayad ng mga producers of graded, yung nagbayad ng mga proprietors, operators kay FDCP, isasauli ba niya yon? Isasauli ba niya yon? Which actually amounts to hundreds of millions, if not billions. As a matter of fact, just for Cebu City, the aggregate deficiency claimed is 100, tumataginting na 159 million. Again, this amount represents the unpaid amounts to FDCP by 8 cinema operators or proprietors in only one covered city. O, diba? Ang laki-laki pala, 159 million. So, now, an exception to the above rule, however, is the doctrine of operative fact. So, ano naman itong palang doctrine of operative fact? Which applies as a matter of equity and fair play. Okay? Ano natin yan? Underline. Lagyan natin ng kulay. This doctrine nullifies the effects of an unconstitutional law or an executive act by recognizing that the existence of a statute prior to the determination of constitutionality, okay, prior, is an operative fact. Nung panahon na yun, tama naman yun eh. Yun yung fact nga, yun yung katotohanan. So, and may have consequences that cannot always be ignored. It applies when a declaration of unconstitutionality will impose an undue burden on those who have relied on the invalid law. Diba? So, ano nga yung, the operative fact doctrine recognizes the existence and validity of a legal provision prior to its being declared as unconstitutional and hence legitimizes otherwise invalid acts done pursuant thereto because of considerations of practicality and fairness. So, in this regard, certain acts done pursuant to legal provision. Okay, certain acts done, ha? I-highlight natin yun. Certain acts done pursuant to a legal which was just recently declared cannot anymore undone. Be anymore undone, because not only would be highly impractical to do so, but more so unfair to those who have relied on the said legal provision prior to the time it was struck down. O nga naman, mahirap din naman isauli yung ganun kalaki, no? Tapos, anong sabi dito? It is now accepted as a doctrine that prior to its being nullified, its existence as a fact must be reckoned with. O, diba? So, ano na mangyayari ngayon? So, yun. So, similarly, as enunciated in the main decision, prior to the striking down of the said provisions, FDCP has a right to receive the kasi based on concept of doctrine of operative fact, they have the right to receive the amusement taxes withheld by the cinema proprietors and operators during such time. So, this right to receive the amusement taxes accrued the moment the taxes were deemed payable under the provisions of the Omnibus Tax Ordinance of Cebu City. Taxes, okay? Ito na yung mga concept natin na gusto nating i-highlight na na-discuss na natin, di ba? Ay, sorry. So, gusto natin siyang i-highlight, pero huwag na bang highlight na hindi na nakikita? O, ayun. Taxes, once due, must be paid without delay to the taxing authority. As the court has repeatedly stated, taxes are the lifeblood of government, and their prompt and certain availability is an imperious need. This flows from the truism that without taxes, the government would be paralyzed for lack of the motive power to activate and operate it. Hence, despite the natural reluctance to surrender part of one's hard-earned income to the taxing authority, every person who is able to must contribute his share in the running of the government. Kasi naman, no, kung sasabihin mo naman, ikaw yung taxpayer, tapos may batas, feel mo unconstitutional siya, so hindi mo siya babayaran. Pero kinakailangan din naman kasi ng government ng pera. So, would it mean na baka naman kasi isipin ng mga tao na okay, baka naman kasi sabi nga dito, to rule otherwise would be, allowing, it is as if we're allowing taxpayers to reject payment of taxes under the supposition that the law imposing the same is illegal or unconstitutional. Okay, so sasabihin na ng taxpayer, ay, hindi na ako mababayad kasi unconstitutional naman yan. However, this would unduly hamper government operations. As the court held in the main decision, obeisance to the rule of law must always be protected and preserved at all times, and the unjustified refusal of the said proprietors cannot be tolerated. So the operative fact doctrine equally applies to the non-remittance by said proprietors since the law produced legal effects prior to the declaration of the nullity, in this instant, petitions. Diba? So, operative fact, tama naman yun, valid naman yun at that time, so dapat kinakailangan i-remit ni City of Cebu yung pera, the amount, the amusement tax na nasa kanilang mga kamay to FDCP. Okay? So, accordingly, Cebu City's motion seeking the non-application operative fact doctrine to retain as well as has been denied. Okay, so yan na, ito na yung final, ito na yung mga decision guys ng resolution, yung final na. So, the motion for reconsideration filed by Petitioner Film Development Council denied with oo nga pala. Yung isang motion for reconsideration ni FDCP, sabi niya, kinakailangan by virtue of the operative fact doctrine. So, valid naman yung batas. So, sabi din ng batas, pag failure ka nang magbayad ng amusement tax sa kanila, magbabayad ka ng, anong tawag doon? Surcharge. Magbabayad doon ng surcharge. Pero sabi naman ni, Supreme Court, hindi, kasi, sabi dito, basahin ko na lang, and finally, the court's true holding regarding the non-payment of surcharges remain. On the constitutionality issue, FDCP's argument is a mere rehash. So, yung and at the payment of surcharges, it must be borne in mind that surcharges are generally paid when the taxpayer is in bad faith. Is in bad faith. Ulitin ko ulit, bad faith daw. Pero sa ano naman nila, yung sa case naman nila Colon Heritage, hindi naman bad faith kasi hindi naman nila alam kung saan talaga magbabayad, di ba? So, this situation, because of the confusion as regards the proper pay of taxes, does not obtain in this case. Accordingly, yung motion nga for consideration ni FDCP with regards to surcharge denied with finality for lack of merit. Now, yung kang CHRC naman, so, di ba sabi niya, hindi naman kasi nagbayad naman kami kay Cebu City, di ba? So, yun nga, kasi nga, nagbayad sila kay Cebu City, sabi nila ng court, sige, i-prove nyo na lang talaga na nagbayad ba kayo, tama ba yung nabayaran nyo na tax. Kaya na-remand siya sa RTC of Cebu yung case. Now, yung last naman, yung sabi ni Cebu City na, hindi na kami magbabayad hindi na namin i-remit kay FDCP kasi nga, unconstitutional naman at invalid yung law. Sabi ng Supreme Court, hindi, kinakailangan ibigay mo kay FDCP kasi under the Operative Fact Doctrine. Okay? So, maganda pag-aralan yung law, guys, no? And hopefully, may natutunan kayo dito. So, taxes, sabi nga dito, taxes are the lifeblood of the government. Isa yan sa mga basic talaga. Taxes, yan. Without taxes, paulit-ulit talaga yan. The government would be paralyzed for lack of the motive power to activate and operate it. Hence, despite the natural talaga na hindi natin gustong bigay yung part din naman ng hard-earned money natin. Every person who is able to must contribute his share in the running of the government. And hopefully, this case, guys, enlighten you in some way or one way or another, no? Na maganda din naman yung tax pag-aralan. Okay, and I think that would be all for this video, guys. Thank you for tuning in. Good night!